Hey everyone, welcome back to the channel today. We are breaking down a courtroom moment involving a self-described Moorish American who refuses the name listed on the court file. Instead of dealing with the charges, he challenges identity and authority. The judge remains calm and procedural, but the clock keeps moving forward. Warrants do not pause for philosophy. Paperwork does not change itself. Courts rely on records and presence, not alternate titles or wordplay. This hearing shows that reality does not bend to personal belief. Two separate matters are on the docket, both moving whether he agrees or not. Choices made here have consequences, especially when warrants are active. This case sets the tone immediately, so let us get into it.
Hello, sir.
How you doing?
I'm good, thank you. What's your name, sir?
If I can help you.
I'm Williams L.
Yes, Your Honor, but the defendant is identified in the docket as Michael Williams. Is that correct, sir?
Yes, that's the name they're calling me, but I am Williams L.
I understand.
Michael Williams. Okay.
No,
Mr.
I'm not
Williams,
Michael Williams, Your Honor.
Okay.
I am Williams
Okay.
L.
This argument shows up again and again. Defendants try to split names from people, hoping the case collapses on technical error. They believe refusal equals immunity, but courts do not work that way. Identity is established through records, prior contact, and legal documentation, not verbal rejection in the moment. Saying that is not my name does not erase past actions, it does not undo signatures or stops, and it does not end jurisdiction. Judges have heard this playbook before. It rarely slows the process. Instead, it often makes things worse because cooperation disappears, confusion replaces clarity, and patience wears thin. The tactic sounds clever online, but fails in real courtrooms.
Okay. So here's the thing, Williams L. I have to call you what's on the documents that I have present for me in court today. We can either handle it that way, or you don't have to handle it, and then it just will be like you didn't show up to court today.
No,
So it's
Your
either
Honor,
way,
I'm just
but I
letting
have
you
to
know
call
who I. Your Honor, I'm just letting you know who I am.
Okay.
I am Williams
That's fine.
L. I am not Michael Williams. They kept calling me Michael Williams. I told them who I was. I am a sovereign Moorish American. I'm not United States citizen, Negro, Black, or colored, Your Honor.
Okay, so let me tell you, Mr. Williams, this is the last time I'm gonna say it. This is all I have for you. If you don't want to handle it under that name today, then I have to act as if you aren't present, and so that's fine. But I
You
have
say
to
what?
call
Hold
you
on.
what's that document, okay?
Can you repeat that? Can you repeat that,
I
Your Honor?
said, if we can't handle those matters and those tickets that's on that case under that name, then that's fine. But it's going to be as if you didn't appear for court today because I have.
Ma'am, I'm here today, ma'am.
Right. So I'm just saying when I
Williams
call those
L is here
documents-
today. I'm just letting you know
Hold
who
on,
I
Mr.
am, ma'am.
Williams.
Yes, I do.
Okay.
I am Williams
Okay.
L.
So that's fine. When I call it on the record, I'm going to have to call it on the record as the name on the ticket, just so you know. Okay.
Okay, and I'm gonna let you know that I'm Williams L. Okay, I'm cool
That's
with
fine.
that. And I'm letting you know who I am. I'm a
Okay.
Moorish American.
Okay. Did you want to
Sovereign.
offer? Okay. Did you want to offer for it or no? Are you going to try and have? I need to kind of know where you're going. Are you going to want a trial? Are you going to try and want to?
No, I do not agree. I do not agree to none of this. I'm sovereign.
Okay, so if you're not going to participate, we're just going to act like you're not here today, and I'm going to go ahead and.
I am here today, ma'am. You seeing me right here? That's on record.
Listen, just because you show up doesn't mean that you're here. You have to participate. Okay.
Ma'am, I'm a sovereign. I'm letting you know who I am.
Listen,
I'm participating. I do not agree.
Mr. Williams, that's fine. But if you don't participate, saying you're a sovereign doesn't help me.
Calling yourself sovereign changes nothing here. It does not unlock a legal shortcut, it does not pause the hearing, and it does not strengthen a defense. The judge is focused on procedure, not labels or declarations. Every minute spent on slogans is a minute not spent resolving charges. Courts respond to motions and facts, not personal ideology. Belief does not override statute. Incompetence does not equal correctness. This approach often isolates the speaker because it avoids the real issues: tickets, warrants, and compliance. Instead of progress, the gap between belief and law widens. Frustration grows on all sides, and the outcome rarely improves simply because someone says sovereign.
I'm just letting you know who I am. That's violating a constitutional right, ma'am.
So do you want an offer or not? That's my question.
Do I want to what?
An offer to the tickets or not?
Do I want to? I can't understand. You said, do I want to offer?
Do you want
tickets?
an offer? Do you want to try and resolve this today as far as?
Yes, I do want to resolve it. I asked for this case to be dismissed off lack of jurisdiction. Your Honor.
Oh, no, that's not gonna happen. So you can, I'm not
Well,
gonna dismiss.
I'm speaking for myself. I have no attorney, so I'm speaking for myself. I asked for this
Okay, I'm
case to
gonna
be
call that. Give me
dismissed.
a case.
You're violating my constitutional right,
How
and
do
I
you have
ask for your oath of
constitutional rights
office.
if you're not a citizen?
I'm not a United States citizen.
So how are you entitled to constitutional rights of citizens?
There is an important distinction here. Fundamental protections exist for everyone. Access to a judge is one of them. Fairness in process also applies. The court cannot deny a hearing based on citizenship alone. Those baseline protections matter, and they are built into the system, but they are not unlimited tools. They do not erase responsibility, they do not cancel pending cases, and they do not excuse noncompliance. Rights ensure a fair process, not a guaranteed result. Participation is still required. Rules still apply inside the courtroom. Procedure still guides decisions. Ignoring that reality backfires because the system keeps moving whether you engage or not.
You got to uphold to the sovereign, sir. You can't. I'm not United States citizen. I'm not Negro, black, or color. You're not under I'm not under your jurisdiction.
I understand, but my question to you is, if you want to rely on your constitutional rights, how do you have constitutional rights if you're denying your citizenship?
Yeah, because I'm an American. I'm a
I
national.
understand. I get
I'm
it,
a
but
Moorish American. I'm not United States citizen corporate. I'm a Moorish American. I'm an American national.
okay, but you're still present in this jurisdiction, right?
I just asked for this case to be dismissed off lack of jurisdiction. I don't want no attorney. I can speak for myself. I'm not a minority.
Right.
What am I doing here?
He can represent himself. Don't worry about it. You put
I can
yourself on.
speak for myself.
All right.
I'm speaking
Now
for
calling the
myself.
matters
Y'all
of the
violating my
people.
rights. That's a
Now
sovereign.
calling the matters of the people versus Michael Williams. This is ticket number SP 1212334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. Count 3, no insurance misdemeanor. Sir, please state your name for the record.
Let's see if he gets it right this time. Press X to doubt.
I am Williams L.
All right. Sir,
I don't have a name. I have a title.
Beyond basic protections, privileges come with participation. Benefits flow from citizenship and compliance, not from rejection of both. The law separates human dignity from legal advantages. Dignity is universal. Advantages are conditional. Refusing the system while demanding outcomes creates a contradiction. Courts notice that immediately. Judges cannot reward disengagement or hostility toward jurisdiction. Obligations remain in place regardless of personal stance, and distancing yourself verbally does not distance you legally. The record still reflects the case, the warrants still exist, and the consequences still follow.
This is the date and time set for an arraignment on a bench warrant. Do you want to participate in these proceedings?
Yes, I'm here on special appearance. I'm just letting you know who I am.
All right. So how would you like to move forward with this matter, sir?
I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
All right. That motion has been denied. How would you like to move forward on these matters?
I just told you what I would like it, so I don't know. I'm just here on
So it's
special
been
appearance.
denied. So you can either participate today.
I am participating. I'm here. I'm speaking for myself. I have no attorney, so I'm just letting you know. It's denied, so we can keep going on with proceedings. I am Williams L. I'm not a United States citizen. I'm not Negro, black, or color. I'm not Christian.
All right, Mr. Williams, it appears to the court as I'm making a record that he does not want to participate in these proceedings.
I told you I wanted to participate. I'm just letting you know who I am. I told you for the record.
All right, he would like to not participate in these proceedings. He has told me that he is the person known as Williams L. and not the person on these tickets, so he is not appearing on behalf of this person. This person has not made themselves available to the court today as an arraignment on the bench warrant, so these matters will stay in warrant status. Thank you so much. That concludes this hearing. Have a good day, Mr. L. Williams.
Self-representation is a serious decision. It requires knowledge and strategy, not just confidence. Attorneys understand timing and procedure. They know when to argue and when to move forward. Without that guidance, defendants often talk past the issue, repeating points already denied while the court advances anyway. This is where things unravel because misunderstanding replaces advocacy. Participation becomes resistance, and resistance looks like absence. Judges must keep order and protect the record even when someone insists they are present. Knowing the rules matters here because the system does not teach mid-hearing, it simply proceeds.